Hello to everyone in New York, New Jersey, Connecticut, and around the world. I'm Dr. Sam Bowden Akbari, Director of Communications at Regional Plan Association. Welcome back to RPA Radio, your source for urban and regional planning discussions around the tri-state region. Today's episode is the second in our Region Watch series that looks at how unprecedented federal actions are threatening our collective prosperity and regional planning priorities. Part 2 of Region Watch features a great conversation between RPA's Executive Vice President, Kate Slevin, and special guest Brian Farkas, partner at the law firm Arendt Fox Schiff and instructor at Congestion Law School. Brian helped RPA draft its amicus brief to the court case that's currently pending between Secretary of Transportation Sean Duffy and the MTA. The two discuss the legal challenges to the nation's first ever congestion pricing program and take a deep dive into the case that's currently pending. Take it away, Kate.
So, Brian, thanks so much for joining us. It's really great for you to spend some time with us today to talk about congestion pricing. I know Sam gave a brief overview of your background, but is there anything else you think the group should know about who's listening today?
Sure. Well, the most important part of my biography, besides just being a lawyer, is that I'm a lifelong New Yorker. So I have a deep personal vested interest in our transportation system, our subway system, and RPA's mission, which I hope we'll get into during our conversation.
Great, thanks so much. And you also worked on this with a colleague at Arendt Fox Schiff, who's also a lifelong New Yorker as well, right? And you were both contributing your time and expertise to help us file amicus.
That's true. I worked with Rachel Levin and James Pizzo, who both are lifelong New Yorkers, and I think there's something about being, a native that really makes you feel a certain affinity to the subway system, beleaguered as it may be.
Yeah. So thank you for joining us today on this episode. And we're really lucky to have you and your colleagues help us in drafting this amicus. But before we even go into talking about some of the specifics of the amicus and some of the other legal challenges that are out there, can you tell folks today who aren't lawyers what an amicus actually is?
Absolutely. So generally in any litigation where you have a plaintiff and a defendant who are fighting with each other, usually in 99% of cases, the only people who the court actually hears from are those parties, the person who sued and the person who's getting sued. The plaintiff and the defendant, and of course through their lawyers, are the ones who communicate with the court. But sometimes, in some cases, there are issues of public interest that arise. Maybe it relates to healthcare, maybe it relates to the economy, maybe it relates to technology, but maybe some issue in the case has broader significance beyond just the individual person who's suing and the individual person who's getting sued. So in those situations, the rules of procedure that govern in our courts allow non-parties to the litigation to file what's called an amicus brief. And amicus, for those who have not taken Latin in their middle school and high school careers, means friend. And so an amicus brief literally means a friend of the court brief. And the idea with an amicus brief is that it's meant to provide a perspective to the court that would not typically be available to the court through the parties. So maybe the parties are not in a position to articulate certain information that someone who is playing the role of an amicus could play. So I can give a few examples of that. These commonly come up are commonly filed in Supreme Court cases where there are inherently kind of issues of national significance that come before the Supreme Court. And so sometimes you'll have interest groups or academics who have specific expertise in certain areas who can inform the justices or depending on the court, the judge in certain areas that are implicated by the litigation, even though that person or that group is not a party to the litigation.
Great, thanks. That's really clear and helpful. And how important are these friends of the court briefs? I mean, do the judges really pay attention to them? Are they really taken into consideration as they're considering a case?
That's a really important and interesting question. There's been a lot of scholarship on that exact question, which is how much do these things matter? There are a lot of lawyers and law firms and parties who spend a lot of time filing, drafting, perfecting amicus brief submissions, and I think it's pretty unclear as to what effect they might have. But the real answer is that it varies a lot depending on the issue and depending on the judge who might be reading it. Now, I think there are certain types of amicus briefs that are more persuasive than others, and let me say a little bit about that because I think it leads directly into the conversation about congestion pricing and why RPA's brief I do believe is actually on the helpful side of that equation. But let me say a bit about when briefs maybe are not so helpful. If a brief merely repeats what the parties to the litigation or one of the parties has already told the court, that's probably not so helpful because judges are already inundated with submissions, especially in a case like the one we're about to talk about that's heavily represented by good lawyers on all sides. Those lawyers have generally provided that party's perspective. So if you have an amicus who's just chirping in and saying, "Oh yeah, me too," and kind of just adding their sort of reformulation of the same points, probably not so helpful. And I would also say that a brief that is overly partisan sometimes can be not so helpful depending on the court. Sometimes those types of briefs can be disregarded or taken at least a little bit less seriously by judges and justices who do try to separate out the political from the legal. And we can have a whole separate conversation about that, but I think it's actually, again, relevant to the brief that we're talking about today. I think the amicus briefs that are most helpful are the ones that are providing either factual or legal perspectives that are nonpartisan and not represented by the parties to the litigation.
That's really really interesting because when we were deciding whether to submit an amicus, we had a lot of conversations about this exact point, right? We didn't want to just submit something that we didn't think was somewhat unique, I think, and really spoke to our strengths as RPA, an organization that's been around for over 100 years that does research, planning, and advocacy to basically make the region a better place. We have some strengths. We have a research capacity. We have some really strong data folks on our team here, right? So we talked internally a lot about making sure to utilize those skills in the amicus we submitted, and I think we did a good job of that with your guidance.
Yeah, and I think to add to that, RPA, as you said, it's over 100 years old. It's really the oldest metropolitan planning organization in the country. And I think because of that, its name carries a lot of credibility, particularly credibility in a nonpartisan sense, where there's not a immediate association by the general public or by the judiciary that if RPA submits something, they already know what it's going to say. And I think, frankly, there's
Yeah.
a lot of partisan organizations out there that you probably, in some cases, you know what they're going to say just by the name of the organization. And that, I think, is less credible to a lot of judges and justices who might be thinking about how or if at all to really rely on an amicus. RPA doesn't have that kind of partisan association. And I want to just emphasize that's really important in this political climate that we're in right now, where frankly, a lot of the litigation and disputes with the current administration does have a kind of inherently partisan dimension. And again, there are some organizations, some names that might submit amicus briefs where it's like kind of an eye roll almost, where it's like you know what they're going to say before they say it. They're not expressing anything that's non-political, non-partisan. And RPA does again bring that kind of neutrality and gravitas. You're not trying to score points in with one side or the other. That's not really what RPA is all about. And we're about to get into the substance of the brief, but good transportation, it's not a Democratic or a Republican issue. Everyone needs to get to work on time. No one wants decaying infrastructure, regardless of who they voted for. if they live in the greater New York City area, they have an interest in not sitting underground in a subway car that's not moving. No one wants
Mhm.
that. So I do think that RPA's name carries a lot of weight in this area.
Thank you for saying all of that. I mean, we take our independence very seriously and, have fought pretty fiercely over the decades to maintain that and ensure that we aren't seen as one side or another, but we're just really trying to carry out our mission of making the region better. And we're lucky here in our region to have both sides of the political aisle supporting transit investment. And people from the private sector, have been really crucial to um, making the case for investment in public transportation, especially the business community here. And you talk to other parts of the country, and there just isn't that kind of coalition, right, that is supporting transit investment that includes not only kind of environmental groups and transit groups, but also big business groups and real estate leaders. And so I do think that sort of sets us apart. And we've really tried to keep our independence and be able to work with groups, representing not only different political spectrums, but coming from different places and different backgrounds and different constituencies.
That's great. I think that that is only going to help in how the court would perceive what RPA is doing in this particular case.
Great. Well, let's get into the nitty-gritty a little bit. I mean, as you said, there's been a lot of lawsuits around the congestion pricing program since it was started in January of this year. There were a variety of lawsuits filed against the program to try and stop it, to try, in some cases, get a full environmental impact statement conducted. Then there was a pause put on the program last year, and then there were lawsuits filed to continue to advance the program, saying that the pause was not legal. So it's been well litigated, and those are sort of ones that came from within our region, right? There was a lawsuit from Jersey. There was one from some constituents on Staten Island, some other places throughout the region. And I think the one we're talking about today is bigger in scale, right? Because we're talking about a case involving the MTA and the federal government. And so, it sort of, does that mean there's a bigger precedent or a bigger interest in a case like this when you have two levels of government, a state government, an entity that's represented as part of the state of New York, essentially, the MTA is filing suit against an action that the federal government has asked it to take.
Yeah. Oh, wow. You said a lot there. So the the reality of this dispute, broadly defined, is that it has a lot of stakeholders, and maybe we should just start there.
Yeah.
Why is there so much chaos? Why are there so many lawsuits? Why are there so many legal issues here? It's because there are so many stakeholders. People, to put it in really simple terms, commute into the city and from the city from multiple states, from multiple communities, right? So
Yeah.
that means inherently you have a lot of businesses and a lot of individuals who are affected not just within the five boroughs of New York City or even just within Manhattan, which is really the focus of the congestion pricing program, but you inherently have all five boroughs. You have people from different areas of New York State, Long Island, etc., Westchester. You have folks in New Jersey. You have folks coming from Connecticut. So it's a regional issue that inherently implicates local, state, and federal governments. So to your
Mhm.
point, you're always going to have conflict when you have a noisy democracy like the United States. You're always going to have some degree of conflict between local communities, state communities, and a broader federal community where you're looking at the interests of different states. So I think the setup of this is almost, was inevitably going to create litigation that feels chaotic and noisy because it's not a localized issue.
Yeah, yeah. And it has felt chaotic and noisy. I mean, it's been hard to sort of keep track of all the lawsuits and where they stand and everything like that. And um, it's hard to implement any kind of policy change in a city like New York. And then when you have all of those regional players and you have such a sort of high profile policy, right? It just adds to all that chaos.
Absolutely. I think that that is a challenge of policymaking in the city broadly. But
Yeah.
the good news is that when policymaking happens well, you can sometimes, if you do the blocking and tackling correctly, you can
Hmm.
sort of an opening and can create a policy that actually would support everyone's interests, or at least a majority of people's interests, which is, of course, what we should be trying to do in any democratic republic.
Right.
And I think that that is actually what the congestion program tries to achieve and did achieve in its conception when it was implemented in January of 2025.
Yeah, and that's sort of the fundamental point in our amicus, right? Is that the program is achieving its goals, and we cite stats um, to that effect. That's our original research. But before we get into the specifics of the amicus, can you just tell us a little bit about the MTA versus USDOT case that is moving along in the courts right now?
Absolutely. So this is it's a short question with, unfortunately, a probably could be a long answer, but I'll try to keep it short, which is that
Mhm.
um, there was a long history of debate and discussion about what a congestion pricing program might look like, and that goes back decades. The big picture conception of congestion pricing is we have an area of Manhattan that is very congested with vehicles, and it's no surprise to anyone who's tried to drive or take a taxi through Midtown Manhattan at certain periods of the day on weekdays that it's crowded, right? There's a lot of traffic there, especially at certain times of year, especially at certain times of the week, certain times of the day. So there's a lot of negative impact of that congestion. So going back decades, there's been discussion of this question of, is there a way to implement essentially a tolling system that would make it more expensive to come into that congested area during those congested time periods? And what could you do with the money that's collected? Well, a lot of stuff. You can help to fix New York's aging infrastructure with the sort of side benefit, or maybe primary benefit, that um, it would encourage, if the infrastructure were better, the subways, the buses, if that infrastructure were better funded, then you would actually encourage people to commute using public transit rather than commute using vehicles. And there's been historically an underfunding, as we sort of talked about at the
Hmm.
outset of this discussion. There's been a historical underfunding of our public transit system in New York City. I don't think that that's necessarily limited to New York City. I think probably many municipalities around the country would say that their infrastructure system has been underfunded over the decades, but that's inevitably true when you have lots of demands on a government. But I think in New York in particular, there's a sense that our subway system, our bus system really could be modernized in a lot of ways, given just the centrality of New York to the American economy and the number of people who live here and work here. So there's been this underfunding, and the concept of congestion pricing is maybe we can use um, a tolling price system to charge vehicles. And the way that this is implemented, there's the gist of it is that it's under 61st Street in Manhattan. I'm just talking in broad brushstrokes. Cars that enter at certain periods of the day would be charged a fee, a toll, and that money would go to the MTA for the transit improvements that we're addressing. And Kate, if you want to add anything to my broad brush description of the program, feel free.
No, that's great. I mean, it has been debated. I mean, at length here in New York, not only have there been various proposals, but there's, as the MTA was advancing this particular one, there were thousands of public comments, meetings. They set up an independent group with some environmental justice organizations. So there's really been an effort to incorporate community feedback as the program was being developed this time around. And so
Yeah,
I think the
and
program you see reflects that.
exactly. And I think that all of that cacophony of community input and government stakeholder building, consensus building, that all took place prior to 2025. So it all took place. There was debate, there was discussion, as you said, and then this program was actually implemented in January of 2025, beginning of the year. And I think what is really important to emphasize is that the federal government, and I'm going to be sort of just quick in the way that I describe this, the federal government approved it. And I'm using that word advisedly, but the federal government basically put its stamp of approval on the program prior to this year before it went into effect. And what that means is the federal government said, yes, go forward. There was an extensive study, many hundreds of pages, many constituents within the federal government, the Department of Transportation were consulted and involved over a period of years. And ultimately in 2024, they said, yes, go forward and implement it. And I think that is really I guess you could say that the trigger point for the lawsuit that we're about to talk about in New York.
Yeah, and it was also approved, the federal government approved the environmental assessment, right? And then they gave authorization, if you want to call it that, through a federal program called the Value Pricing Pilot Program, which authorizes tolling of federal highways throughout the country. It's not just here in New York. So let's talk a little bit about the actual case. The US DOT sent a letter to the MTA a little bit after the program started and said you have to stop it, right? You have to turn the program off. And the MTA said, no, we don't, right? Is that sort of the layman or layperson's perspective on it? So what's the actual like legal argument and legal case behind that?
Well, as so many lawsuits do, this one sort of began on with a Truth Social post by President Trump. Um, the yes, so there was all of this, development, all of this discussion, all of this approval that was done with all of the groups that you just indicated, and then essentially what happened is President Trump tweeted or posted on Truth Social that he was going to terminate the congestion pricing program as soon as he gets into office. He posted this before he took office, and he said, "I'm going to terminate this program as soon as I come into office." And I think at the time there was some discussion and debate about why he would do that or what it was about the program
Hmm.
that President Trump was found objectionable, and I don't know that it was even certain that he would terminate it at that time, but nevertheless he posted it. And then in after his administration did take office about a month later on February 19th of 2025, the Secretary of Transportation, Sean Duffy, sent a letter to Governor Hochul and the MTA and said, yes, in fact, we are terminating this congestion pricing program, and you are required to stop its efficacy, stop putting it into effect. And remember, the program had already been in effect for over a month at that time, so it was already collecting revenue, collecting tolls from folks who were driving into the city during the appointed times. And so, like a month later, after this massive effort to study and plan and implement it, suddenly the administration at the federal level tells the state, actually, JK, turn it off immediately. And so, as you can imagine, that just created an enormous amount of chaos because, again, there was just so much planning that had gone into this. And then in a very short letter for the Department of Transportation to very quickly reverse its view on this program, it just created a lot of uncertainty, a lot of confusion, frankly, a lot of anger among folks who had worked so hard for so many years to put this into effect.
Right, right. And but New York and the governor and the MTA said, we're not going to turn it off. Instead, we're going to continue the program, and we think we have a strong legal case to have it continue to proceed as planned. And
Yeah, it's
what were
funny
some
to
of the
think.
legal arguments there that they were using?
Yeah, there were a lot. There was a view among the state and local governments, certainly at the MTA, that they weren't going to follow this directive from the Trump administration, and instead they were going to challenge it in court. So on February 19th, shortly after this letter was issued by the Secretary of Transportation, a lawsuit was filed in the Southern District of New York, which is the federal court that sits in Manhattan and oversees New York and other counties just north of New York. And that lawsuit was filed by the MTA, the Metropolitan Transportation Authority, and also by the Triborough Bridge and Tunnel Authority, a related entity. It was later joined by New York State itself. And so there's just essentially a group effort, you could say, by the state agencies to have the court direct that the Trump administration's purported effort to terminate congestion pricing was null and void.
Yeah. And so do you think the MTA has a strong case?
Yeah, we could certainly talk about the legal elements of this, but I think from a practical perspective, if most folks heard the sort of story that we have just told here, you're never going to have 100% agreement on anything in a democracy. That's the nature of
Mhm.
democracy. So are you going to find some people who maybe are negatively affected by congestion pricing and not happy with it? Absolutely. If you drive into New York City and you have to pay the toll, I'm guessing you're not so happy with it. But guess what? There are a lot of things that citizens need to do that they may not be happy with because that is what the majority has decided through a political process. But I think most people who live in a democratic republic also kind of recognize that once a process has been undergone, where input has been solicited and there's been a fair airing of grievances, I think there's a sense that we kind of got to go with it. And at least for some period of time, you can't just be in an environment where you're redoing massive infrastructure policy every 2 or 4 years, simply because there's been an election. And that is what I think happened here is there was a change in the Department of Transportation, and certainly that happens every 4 years. There's a change in administration, but you can't simply make it impossible to do long-term planning at the local and state levels simply because an administration changes. So I think here the kind of common sense, putting the law aside argument is there was consensus that was built. There was a major policy that was implemented. It was just getting going. There was approval by the federal government. And it doesn't really seem fair that the federal government a month later can just say, just kidding, we're reversing course. And all of those years of planning, forget about it. We're just not doing it. That doesn't really seem to honor the democratic process that has taken place. So I think from a common sense perspective, to answer your question, the MTA does have a strong argument here. And we
Yeah.
can talk about some of the legal aspects as well.
Yeah, yeah. I mean, I want to get into the legal aspects, but I did want to point out that the polls are showing that surprisingly, some of the biggest supporters of congestion pricing at this point are actually drivers driving into the zone who are paying the toll, but they're seeing the benefits, right? So it is funny, and I'm sure some of those folks were not excited for it to start, and then they saw the benefits and thought, oh wait, maybe this is a good idea. So let's talk a little bit about the legal arguments that are in the case that we're discussing, and sort of how you see those playing out.
Sure. So there are many legal arguments in the case, as there are in lots of cases. So I'm going to just summarize a high level of what some of these arguments are. There's a concept in the law that basically says that a government is allowed to take an action as long as the action that it takes is not arbitrary and capricious. And that's sort of a legal turn of phrase, arbitrary and capricious. The idea there is if the government does something, it has to have a reason for doing it. It can't just wake up one morning and decide that it's going to change a massive policy, for example. There has to be a legal or factual, I should say, underpinning for why a government is making a decision. And I think that, makes sense to all of us intuitively. We don't want to be ruled by a government that's just deciding to do things on a whim without any level of kind of study or factual support. You always want to have some kind of minimum requirement. And I think if I were to summarize kind of a major legal argument in this case, the plaintiffs are arguing in part that the federal government really did not have a rational basis that was not, quote unquote, arbitrary and capricious for taking the action that it did in February of 2025 when it pulled the plug or attempted to pull the plug on congestion pricing. In other words, there was no factual support really for that determination that was not contradicted by the mountain of evidence and study that we've already talked about from the preceding years that led to the implementation of that program. And in addition, I think a kind of related argument is that the federal government, as we've already discussed, already gave its blessing to this program. And there was no basis for that blessing to suddenly be revoked in February of 2025, like what was different from a month later, other than the election. Really, there was not anything that was different. And so legally, again, I think that comes down to this question of is the congestion pricing program achieving the goals for which it was implemented, for which it was passed? Or did something happen in the interim that suggests that actually, the government put this into effect, but it sucks and it's not working, in which case, like, sure, the government could reverse course if it were not achieving its objectives, but it really can't reverse course if it is achieving its objectives and there's no non-arbitrary reason for reversing course.
And there was this kind of shocking thing for legal scholars that happened where the lawyers representing the Trump administration at the Department of Justice actually, in error, uploaded a document, a letter outlining some of the reasons the MTA had a strong case. Do you want to just talk a little bit about that?
Yeah, I hate to criticize lawyers because they're my fellow species, and so we don't like to criticize one another. I think any lawyer can make a mistake. Every lawyer makes mistakes, and the truth is, lawyers have really hard jobs, especially those at the Department of Justice who are under just a tremendous amount of pressure. I think now more than ever. With all of that said, what happened here essentially was that there was an internal memo within the Southern District of New York, which is the office that represents the federal government in court cases in the district court in Manhattan. And there's this internal memo that was written that essentially provided a sort of warning that the federal government's position, the Department of Transportation's position in this lawsuit was not very strong. And what happened, unfortunately, was that memo, which was meant to be an internal memo, was publicly uploaded to what's called the ECF, the Electronic Court Filing Docket. And that memo got then, of course, immediately leaked to the press. And so everyone was sort of criticizing the fact that even the Department of Justice was extremely skeptical of its own client, which is the Department of Transportation in this situation. So it's sort of an embarrassing black eye, I would say. But frankly, I don't think the court is going to make any decisions based on a technical error by lawyers who, again, were probably operating under tremendous stress. But I think that certainly the contents of that memo are relevant to the extent that they show that the government knows that the legal arguments that they're advancing are not the strongest.
Yeah, so I mean, at RPA, we haven't submitted an amicus brief many times in our history. And so we had a whole process internally that in order to come to the decision that we should submit one. And you were part of that, which I appreciate. And a number of our lawyers who were actually on our board of directors helped us as well in sort of figuring out the right direction to go and whether or not it was appropriate for us to submit an amicus. I think in this case, and you can add in here, but I think in this case, the reasons we thought it was so important to submit one was that we were offering up information that was really based on our strengths as an organization. We were providing something that was sort of new and different, and that we had original data that was showing congestion pricing was leading to a 25% delay in traffic in Manhattan in the central business district where congestion pricing is implemented. And that work was done in-house by Rachel Weinberger and Will Cow here. And so, do you want to just sort of summarize the amicus and what we put in there and how it, is relevant to the case that the MTA is pursuing?
Absolutely. So let me set it up with just a few sentences of context, which is that this lawsuit, as I mentioned, was filed in February of 2025. And since then, there's been some procedural movement and stuff over the last 4 or 5 months. And then the parties filed what's called summary judgment. And summary judgment is basically like each side puts together all of their evidence and legal arguments and hundreds of pages of material from the plaintiff and the defendant. The plaintiff here being the Metropolitan Transportation Authority and the defendant being the federal government, essentially. They put all of their material before the court, all of their respective arguments. And what they're each asking for is basically opposite relief. So the MTA is asking that the federal government's decision to pull the plug on congestion pricing be declared invalid, basically like legally null and void. And the federal government, on the other hand, is saying, no, actually, it should be given full force and effect. We're the federal government, and we made a decision. We were, duly elected and made a decision about transportation infrastructure that's within our scope of legal authority, and the court should recognize that. And the plug actually should be pulled on congestion pricing. So that's the nature of these, what we call summary judgment briefings. The case has not been decided yet, which means that the court is currently considering the parties' submissions and our amicus brief as part of its determination. So with that, let me just say a couple things about our argument in the amicus. RPA has argued through its brief that, remember that arbitrary and capricious, that funny legal phrase that I used, what we were trying to show through this amicus brief is that actually the congestion pricing program is achieving the goals for which it was implemented. And remember, if we can show that it is achieving the goals for which it was implemented, that kind of suggests that the Department of Transportation's sudden decision to just pull the plug on it was arbitrary and capricious. So that's why it's legally relevant to establish factually, is the program achieving what it was meant to achieve? So with that said, we compiled from RPA's original data, as you indicated. RPA has amazing researchers and folks who really dedicate their lives to studying these important infrastructure questions. RPA analyzed a lot of mobile traffic data, for example, that came from Waze, the mobile company. It's a subsidiary of Google. They were able to do a lot of really firsthand analysis of traffic data and other data points to conclude that actually, yes, that the congestion pricing program is achieving exactly what it was meant to achieve. And not only that, Kate, it's doing it better than we ever could have hoped for. So it's not like this is some failing program that the government is pulling the plug on. This is actually a super highly successful program that is achieving exactly what the federal, state, and local governments wanted to achieve. So let me say a couple things about what those achievements are. The first is that it's significantly, since it's gone into effect, the tolling program has significantly reduced traffic and vehicle congestion in what we call the major kind of congested area, the major business district in Manhattan below 61st Street. Congestion has been significantly decreased. And so RPA studied the period of time before the congestion pricing program went into effect from a similar time in prior years and compared that to post-implementation and found that there was a significant decrease. In fact, a 28.4% decrease in traffic, and that not only was there that 28.4% decrease in traffic, but the drivers earned back about 17 minutes for every hour that they spent in traffic compared to the same period in 2024. So that is pretty clear evidence that, in fact, this is really a success story in terms of giving commuters back time that they did not have before the implementation of the program. We have some data that's in the amicus brief that for listeners of the podcast who really want to get into the weeds, you can find the amicus brief on RPA's website. You can see some nerdy charts and data that shows that. We were also able to show, RPA was able to show that the holiday season was even more pronounced in those positive effects. Another positive element is, remember that the government wanted to implement congestion pricing specifically in order to gain revenue for the MTA, for public infrastructure. And the results here are just completely undeniable that already the MTA has taken in significant financial revenue, even in just the, however many 9 months since congestion pricing was implemented, 10 months, there's already been significant revenue from the tolling program. And what our brief shows is that the MTA is on track to generate about $500 million in revenue in just its first year of this program being in effect.
Yeah, and I should mention that, we looked at the environmental assessment when it was being prepared, and I think number one, looking at those statistics now versus what's actually happening in real time, it's pretty shocking how close the model predicted what was going to happen. And the other thing I think that we found in our analysis and other studies have found is that some of the concerns that were identified in the environmental assessment as congestion pricing was being studied, specifically under one of the scenarios, a potential to increase traffic in parts of New Jersey, parts of the Bronx, and parts of Staten Island, have not come to fruition. And our analysis found that as well, and supported that, and found that there's actually been traffic reduction in those places, or really not much of a change at all.
Yeah, that's such an
So
important point that I think some people might characterize this as like, oh, it helps people who live in Manhattan or people who live in the 5 boroughs, but it hurts the people in Westchester, New Jersey, etc. That's not really true, as you're pointing out, and that's absolutely a point that we make in our brief.
yeah, and I think some of the biggest beneficiaries of this program right now are actually bus riders coming in from New Jersey, because they've seen just, huge reductions in delays, specifically at the Lincoln Tunnel, coming into the Port Authority. So lots to like about congestion pricing.
And there's
So
another important benefit too, which is, I mean, that we could go on and on listing benefits, but our brief also discusses emergency vehicles. They can
yeah,
travel, response times are faster after congestion pricing was implemented because there is no, there's less congestion on the streets. So from an emergency services perspective, there's also really a benefit to the community.
yeah, yeah. And it is noticeably different. I mean, our office, I'm in the zone, the congestion zone, relief zone right now. Our office is here, and there is a noticeable difference from day one that still exists in terms of traffic reduction and just the feeling of being a little bit safer from traffic when you're walking around. But we're running out of time, so I want to ask you to just sort of lay out where we are and what some of the next steps are that our listeners can pay attention to and look out for.
Absolutely. So where we are procedurally is that all of this content, these arguments are all before the court, and it's before a judge named Louis Lyman, who is known as being a pretty down the middle, really bright, really hardworking judge, federal judge in again, the Southern District of New York. Judge Lyman was appointed by President Trump actually in 2019, but he's known as just being a really hardworking, down the middle guy who has a very high level of intellect and a very highly incisive view on these legal issues. He clerked for Justice John Paul Stevens at the Supreme Court. He also was an assistant United States attorney in the Southern District of New York and rose to become deputy chief of appeals. So he really comes from a tradition that I think is very public service oriented and not someone who is known as being particularly partisan on any legal issue. So, we have a very good judge on this case, which is, I think, from a lawyer's perspective, is always a great thing. Procedurally, where we are is Judge Lyman had implemented back in May of 2025 something known as a temporary restraining order and a preliminary injunction. And what those legal words basically mean are that the judge decided that he was going to essentially pause the Trump administration's attempt to rescind congestion pricing. So remember, the timeline here was in January of 25, New York put into effect congestion pricing. In February, the Department of Transportation tried to rescind it, and the lawsuit was filed challenging that. Judge Lyman basically said, all right, we're going to let congestion pricing continue during the duration of this lawsuit until I make a decision on the merits of the lawsuit. So right now, where we are, to your point earlier, Kate, is that congestion pricing is happening. It's implemented. So right now, we're in the state of the world where it looks as if it would look if congestion pricing had just been implemented without any federal interruption. Now, that could change depending on the adjudication of the summary judgment motion before the court right now. And that motion is now fully briefed. We would expect that Judge Lyman will issue a decision on that as soon as he is able. There is a lot of content for him to read and review, as one might imagine in a case like this. So I don't anticipate that's necessarily going to happen tomorrow. But I will say he's known for being very careful, very thorough. His decision on the preliminary injunction was over 100 pages, very carefully reasoned. So I would anticipate that the court is probably working on a pretty thorough, pretty substantial decision on these issues. And once there is a decision, I'm sure that RPA will be the first to let people know.
Great, thank you. And I'll also mention that we are part of a bigger coalition of supporters of congestion pricing, and a number of them have filed their own amicus or actually parties to the lawsuit. And, some of them are, just to give them a shout out for all their hard work, Natural Resources Defense Council, Riders Alliance, New York City Environmental Justice Alliance, New York League of Conservation Voters, and many, many others. And I can't name all of them today, but there's a whole group of folks working on this, trying to keep congestion pricing in place. And we're just so appreciative to you, Brian, and to your legal colleagues for helping us. And, not only in writing the amicus, but your guidance and your dedication to essentially using your legal skills to make New York a better place. So thank you so much for all of your help and support. And you have any final last words for the discussion today?
It's been an honor, and I'm really, on behalf of my colleagues here at Arendt Fox Schiff, we're a law firm that really does try to do a lot of pro bono work and tries to advance the communities that we operate in. And one of our largest offices is right here in New York City. And as I said, I'm a native. The other folks who worked on this brief with me are also New Yorkers. James Pizzo, Rachel Levin, Sarah Fitz, all of us have worked on this from Arendt Fox team, and we're honored to partner with an organization like RPA, and our fingers are crossed that we'll get a good result here.
Great. Well, Brian Farkas, thank you so much for joining us today and for all your efforts on this. And maybe we can bring you back on once a decision is out and we know a little bit more about where things stand.
Absolutely. We'll record the next episode from the Q train.
Sounds great.
Take
Okay,
care.
thanks, Brian.
If any of you transit nerds and legal historians would like to dive into the full compendium of cases seeking to append the congestion pricing program, our friends at Natural Resources Defense Council, Anushka, Limaye, and Eric Goldstein helped me collate such a list, and we'll link to that in the show notes and on our website, rpa.org. Until the next one, remember, think regionally, act locally. Goodbye.
RPA Radio is produced by Sam Bowden Akbari for Regional Plan Association. Editing is by Megan McElroy. Our theme music is by Nate Dorr. Questions or comments? Email us at info@rpa.org or visit rpa.org for more.